Good afternoon, everyone. My name is Nishanthi Nehru. I'm the lawyer, founder, and director of Nehru Law Professional Corporation, which is my law firm. And today I will be talking about director and officer duties and liabilities. This webinar will provide an overview of key responsibilities, legal risks, and ways to manage those risks effectively within the Canadian corporate context. This is important, so stay tuned for all the information that we're going to provide. But first, I'm going to speak about myself a little bit, just doing a little introduction if anybody is new to the webinar. I have been a lawyer for the past year and a few months, but I have been in the court services for over 8 years. I have extensive legal experience in family law, civil litigation, and criminal law through my work experience with Court Service Division and also working with justices, lawyers, and legal staff. I have extensive experience in those areas due to my constant being in court as well as dealing with administrative paperwork. So that I bring quite a lot of information and knowledge into my practice and am able to assist you in various ways. So please contact me if you need any assistance, and we will discuss your matter thoroughly and deal with it accordingly. So now let's talk about fiduciary duty overview. What is fiduciary duty? This is important because fiduciary duty is the cornerstone of director obligations. Directors must act in good faith, prioritize the corporation's interests, and avoid personal gain for their benefit. This means that your interests are the corporate's interests. You cannot have interests within while you're working in the corporation that conflicts with the corporation. Your duty is to make sure that the shares and stocks and any type of a venture that is entered into by the corporation is satisfied and that you're doing it in the best interests of the corporation. Now let's talk about another segue. This is important as well. Under director's liabilities, under director's responsibilities, you have a duty of care. What is a duty of care as a director? This requires directors to act with the due diligence and care of a reasonably prudent person. This includes considering the impact of decisions on shareholders, creditors, and the long-term health of the corporation. Duty of care is important because duty of care allows you to make sure that you're acting with due diligence. If you have a decision to make within the corporation, before making any decision, your responsibilities are to make sure that you have done every act possible to review, to conduct a search if you're not understanding the material, to actually consult with an expert advisor and make sure that the information that you're obtaining is appropriate for the corporation and that it benefits the corporation in the best way possible, and that the stakeholders' interests are also maintained. The stakeholders, these are individuals who are either investors, creditors, shareholders, as well as any vested person who has interest in the corporation, but also is a member of the board, or if they are, like, it really depends on the circumstances and the type of business that you're actually in. Because depending on the business, you might have a board of directors, you might have a board of members, or you might have a shareholder board. These are all different types of boards, and they all represent different types of relationships with the corporation. So, as a director, your responsibilities go beyond just the corporation in some instances. And if you're obtaining debt for the corporation, this is where your fiduciary duty and your duty of care come into play, and they become an impact on you. As a director, you can become liable for these aspects. And in some instances, even an officer who's a manager can become liable. In Delaware, they have a case where the officer has become liable for the actions that he committed while working with the corporation. So this case can be imposed on Canadian courts if an officer is seen as creating a substantial impact that's harmful to the corporation. So remember, when you're doing your duty of care, which is due diligence, and you're taking the reasonable actions, that means if you don't have the requisite knowledge, that may if let me explain that a little bit more appropriately. If you don't have the knowledge base for an accounting financial perspective, where your books, you have to manage your books and you have that responsibility, you will need to hire a person who has expertise. Although you may be able to get advised by this individual, always make sure that you're actually reviewing the complete circumstances of the um, the issues, and also if there is any concerns that doesn't make sense to you when the advisor brings this information to you. These are also things that you should be speaking to, like maybe another advisor or an external expert who you can actually consult with. So remember that your choices are not limited, and you need to make sure that you have reviewed all of your possible issues and concerns. Furthermore, like when I spoke about duty of care, this is also applying to duty of care because you're doing everything in the best interest of the corporation. This means the directors owe their duty to the corporation, and duty lies to the corporation and not to any person who is appointed to do them. So you also would have to review the business judgment rules. So what is your best possible judgment as a director under the business guidance that you would have to make? Directors may decide matters on judgment calls based on the interests of the corporation, and they have to make sure they have reviewed all avenues before making those judgment calls. So these are all important things to consider. So remember that also you will have to consider the conflict. So let's go to the disclosure of conflicts. These are conflicts that can arise when you're dealing with contracts or investments, or let's say your products, any kind of different forms of interactions that may arise throughout the course of you being a director. As a director, your responsibilities extend way beyond the just minimal, okay, I am not an officer, even if an officer has these responsibilities, but the director must be looking at all the concerns that occur within the conflicts. So this means that as a director, you will have to disclose specific types of conflicts made to the you will make sure that any offers or ventures made to the corporation that you at that time may have not had interest in, but eventually do find that there is interesting, then you would have to disclose that. You would have to let the corporation know. If they're stakeholders or shareholders, you will have to let them know. However, if you're an individual director who's dealing with one corporation, that's your own sole corporation, you are the stakeholder, you are the director. So you would, depending if you have a creditor, you might have to let the creditor know about your ventures to make sure that they are aware of any possible repercussions, or if there's a debt that might, if there's a risk that the debt will be not repaid by the corporation, then those are things that will have to be disclosed. And they would have to be done in writing so that the any stakeholders are aware of this information and the nature and extent of your interest in this venture or product or whatever it is that was brought to the corporation's attention and your attention as a director, and at which time you may have been interested at the beginning, or you may become interested in the future. Whichever it is, you will have to disclose this information, and including any material contracts. So if there's any contracts that may impose a negative impact on you as a director, or on the corporation, as the corporation may lose funding, these are important to consider and make sure that you are actually discussing them with the stakeholders and that you're providing this information. Also, any existing or proposed ventures that may be on the shelf, or any of these and the nature of interest that you have in these ventures will all have to be provided in the disclosure, so that you are showing that there is no conflict of interest between the ventures that you are dealing with, or any kind of contracts that you're dealing with, even on behalf of the corporation. Let's say you're dealing with you see a venture on behalf of the corporation that's interesting as well. This is also something that can arise to be a conflict. If, let's say, your family member is on the other side of this contract and they are building the building that your corporation is about to invest in, and this corporation has stakeholders that is not you. So consider these possibilities. If you have a familial relationship or a relationship with the other opposing individual that you're contracting with, then these are all conflicts that can arise in the long term because you had a vested interest in promoting this individual. So, what concerns would you want to make sure to address in these issues? These are things that the stakeholders may want to have knowledge of in case they want to make sure that there's insurance to protect themselves, or they may see it as a conflict and need to review all of the issues. And those are things that may concern your position and create liabilities on the director in the future. So consider all of these possibilities before you enter into an agreement with a corporation, with another vested interest contract that may bring financial gain to you as an individual rather than a director. Or even if you do it on behalf of the corporation, your business rules will be the ones you'll be relying on. So make sure you have actually reviewed this with either a third party expert or an individual that has knowledge base under let's say it's construction. Let's just say I have no idea how construction works. Now, if I'm investing in construction and the costs keep going up, now my company is losing funds and we keep getting loans to pay off these funds. These are concerns to the stakeholders as me as a director. So this would also be something that you would have to review with an expert, maybe in someone who is an architect, who can tell you the costs and the fees and provide you with a report that would be more appropriate for you to understand what the long-term gains and the or long-term pitfalls can come out of this venture. So consider these aspects before you actually deal with any contracts on your own behalf or on behalf of the corporation. Now let's talk about corporate opportunities and being loyal. So in this instance, directors cannot take business opportunities that belong to the corporation or use confidential information for personal benefit. This is a part of the loyalty obligation. This is pretty straightforward. You can understand why this is relevant. If a corporation has hired you as a director and you've taken a contract or an interest that they've another party or a stakeholder has brought to your attention, as it would increase the value of the corporation. And now, if you take interest in it and you commit to a contract with it, with that individual without telling the corporation, or even if you tell the corporation, it may become a conflict of interest. So these are things that all individuals must consider. What is your loyalty? Who is it owed to? How should you be able to make sure that you're maintaining that loyalty as well as doing your job? And if you are looking for personal interest, I would always suggest do not try to review the criterias that are within the corporation's contract with you as a director, as well as make sure that you have director's insurance to protect you from conflicts, because a lot of people do not understand. They go into it blindfolded and they don't realize that there are certain aspects of the contract that indicates there are conflict of interest and there's loyalty requirements. And you're not allowed to have any contract you're not allowed to sign any contract on your personal basis if you're working for the corporation and the corporation has brought those contracts in, because then you're actually taking away funds from the corporation and you're a competition to the corporation. At that point, the corporation may see that you are actually trying to bring them down and create a demise on the corporation's behalf, which is not an acceptable practice for a director. There are so many different aspects of this that I could continue to speak about, but loyalty in itself is an understood fact. Under Make sure that you're not exploiting the corporation for your own benefits. Basically, that's the end all. Like, if you are in a position that you are the director, you are the corporation, and you're doing everything in the best interests of both, then you will be able to deal with this in an appropriate manner. And that's what the corporation requires. That using your business judgment rule, you'll be able to figure out what is in the best interest of the corporation and how it benefits the corporation and how you could assist the corporation. Now let's talk about stakeholder interests and best interests of the corporation. Directors must consider a broad group of stakeholders when acting in the best interests of the corporation. This includes long-term planning and non-financial considerations. So what does that mean? This means you have a duty to extend beyond the shareholders. The shareholders, they're looking at the financial gain. You, as a lawyer, as a director, you will be literally making sure you're not only taking the limited aspect of financial gain, but you're looking at long-term projections, long-term goals. What is the employees' relationships? How much financial benefit is it to hire individual? What type of credit or debt is the corporation or should the corporation be obtaining? These are all considerations that should be done. And in doing so, if you have no expertise in these areas, Make sure to consult a lawyer regarding the contracts. Make sure to consult an accountant regarding any financial matters that may seem appropriate at the time, but can go really a different direction in a couple of years, because you may have a great relationship with that individual, but the whole time that individual was using your financial means to gain funds for their own access. So you have to make sure that you are reviewing these issues on a regular basis and looking at all the accounting practices, as well as looking at the contracts to see if they're going to benefit you or harm you in the long run, by speaking to a lawyer who has expertise in contracts, or even reviewing a contract with a lawyer who has the knowledge and understanding of what contracts and how contracts are formed and what the basis and how as a lawyer, I usually review a contract and I go through case law to determine the aspects and different issues of the contract. I also look at the claims and the issues that may arise. These are things that are important to your business, because at this point, individuals don't consider, like when they're starting off their business, they're considering only the minimum requirement. However, if you don't protect yourself, how would you actually be able to gain full long-term goals and success? Because in the long run, you have debtors, you have other resources, you will have financial responsibilities, you will also have other burdens like employees, and these are all things to be thought out. Even if you're midway through your career or your corporation, these are things to consider, because you will have to make sure that any contract that you're making will not have a negative consequences, or at least be aware of those consequences, so you actually make a plan to protect yourself throughout the process. These are important, because when you end up failing to pay one bill, those creditors, those stakeholders are not going to wait until you have funds. In some cases, they expect you to pay at them right away, or they terminate your agreement and take you to court for a debt that's owed and has not been paid. So consider all of the factors before going into it. Just because a loan says there is no personal guarantee on a director does not mean they're not going to sue you, so that you have now personal liability as a director, which you will have to defend yourself against. So consider all of these issues. Okay, now this is where we're talking about case law. Although I'm not going to go too deep into what a derivative action is and what a oppression remedy is, I will let you know these are the type of actions that are brought against a director for their lack of due diligence or their lack of duty of care. And these are remedies that are provided to the corporate, these are remedies that the corporations or stakeholders can bring against the director for their responsibilities. In so doing, it allows that uh, it allows the corporation or the shareholders or stakeholders to sue the director for breach of duty and on behalf of the corporation, and it allows them to obtain funds from the director directly for any financial losses. That means if it's in the millions of millions, can become liable if it is seen that you have lost your you have not did done sorry, my apologies. It's been a long evening, long day yesterday. So I'm kind of a bit tired, so excuse me if I stutter my words. What I was trying to say is you have to do your due diligence. These are important. Any director with your if any contracts or agreements, or I even myself had someone contact me, ask me if I wanted to be an independent contractor, and for me I thought, okay, that was interesting. And then when I spoke to the individual and I said, okay, this contract seems it really good. However, there's some concerns. And I said, okay, I don't know how to play it out. So let me talk to a colleague. And then I said, let me talk to my professional guidance. So these are steps I took before I continued. Because if I had signed the contract and the contract became a fraudulent contract in the long run because it was inappropriate, then I would be liable. I would be the one out, and I would be the one who would be costing myself millions and as well costing my clients funds because they would lose out on my firm and I would have to close down practice. So these are all things I have to consider, as well as I am a director of this corporation that I have created. But although this is my personal corporation with and my own law firm, I have to be really careful about doing my due diligence in this aspect, or else I have lost my I have not done my duty of care, and I've not done my fiduciary duty. Now let's talk about case law. This is a particular case in which the fiduciary duty was stated by the court as the most appropriate way to deal with fiduciary duty. And in this, directors breached the fiduciary duty by failing to act in the best interest of the corporation. The Supreme Court emphasized duty to the corporation, not to the individual stakeholders. Importance of honesty and good faith. The stakeholders are always going to be there. They are always going to have an input and an interest in the corporation. However, the corporation itself is a separate entity. So remember, as a corporation, you will have to make sure that the corporation's interest is first and foremost before the stakeholders. The stakeholders will be categorized in that duty of fiduciary duty. However, their fiduciary duty does not come before the corporation. The corporation is your responsibility. You must make sure that that corporation is always successful. Think about it as a child who is growing up. You have to protect that child, you have to invest in that child, and that child will grow and become let's just say, they become a multimillionaire. Now, they are making money on a consistent basis. But you, as a director, have to be the one who's taking that responsibility to grow and to give that child the care and due diligence and make sure that they are not harmed and protect them against all outside sources that can be harmful, obviously. So this is basically what it means to be acting with honesty and good faith with a corporation and taking care of the corporation. It's basically making sure that the corporation's success is done with proper review of all documents and proper understanding of any agreements that if you don't have an understanding of the agreement, don't pretend that you do and sign an agreement and then expect it to be, oh, perfect and there is no harm. Because if an agreement has some kind of malicious intent that you are not aware of, this can become very difficult for you because you didn't actually properly review the contract, and then you ended up basically not paying attention to your corporate responsibilities as a director, which causes liability on you. So think about all of these before you actually act. Our second case here is BC Inc. and debentures, 1976 debentures. It's a 2008 case. It clarified that directors may consider various stakeholders' interests and long-term outcome. The court supported business judgment rule for balancing those interests. So here is a case where the directors can show that there is an importance to stakeholder interests and long-term outcomes through the business judgment rule. The business judgment rule is actually very important. It doesn't mean just, oh, yes, I know. You have to use it in a way that shows that you have the requisite knowledge and the understanding, and you have done your basic review of what you need to do. And what is that review? That review means that, have you relied on any sources? Have you checked with any experts? Have you were you like, I mean, if it's something that is outside of your knowledge base, have you spoken to those individuals who have the knowledge base and understanding to continue and to deal with those um, ventures? Are you able to understand what is going on in those contracts? Is the financial debt appropriate? These are all things that should be considered by a director. Are you managing your officers appropriately? Are you guiding them? Are you taking their word, and are you reviewing their materials? Even if you don't have that time, in some instances, it would be prudent to make sure that you've reviewed any reports that are brought to you by the office or your officers in the corporation. And this can cause negligence on your part if you do not actually properly review these sources. Even if you have time restrictions, they can still be an impact on your liability, not the officers, because the officers did their due diligence by providing you with the reports. Now, you can't just sign off on it and expect it to be all good. Make sure that you understand what's in the context of the signatures that you are providing. Liability under the securities laws. So I'm just going to do a basic understanding. The securities laws is very complicated, and it's very important to be speaking to a lawyer whenever you're dealing with securities laws, because you will have to disclose specific required information, including any kind of environmental issues. If you're dealing with a property, you will have to indicate environmental issues. That means climate change is affecting everything, and they have specific requirements to make sure that there is no erosion under the building, so causing collapse, or the building has been appropriately situated. You're not actually getting any, you're getting the permits you need. You're not damaging any property around it. There is no water running near the building. See, these are things to be considered. So if you are in the position where you're dealing with a building, make sure you speak to an environmental organization. There's many municipal environmental resources that actually provide you with what type of environment you're situated in, and if you can build or if you can do specific work on the property. And those environmental organizations are within the municipality that can be reached if you just search them outside, look into them. That's important for all directors or even anyone who's owning a corporation. So consider these facts so that you can make sure you're protecting yourself, because they will fine you a hefty fee, and it will be an impact on you if you have to go through hoops to be able to get a permit or to get a license to operate your business in that area. Limits in indemnification. This is important because directors they cannot be limited. You cannot indemnify breaches of fiduciary duty. You can indemnification is limited to good faith actions. That means as long as you're not acting in bad faith, which is an important factor, because if you're doing anything that's unconscionable, let's say your business practices are not very appropriate in that you're not paying the taxes and you're claiming a lot less, or you're communicating with individuals about doing cash jobs or just so to avoid taxes, or if you're there are multiple examples of acting in good faith, like preparing a contract that creates a burden on the other individual and making it uh, implied that it would be effective as soon as they sign it, yet you're reversing documents that are from previous that are already paid previous invoices. There are various practices that are considered bad faith, and consider all of these acts before you do them. Are they under the regulatory practice? Is it appropriate for you to do that? Is there a requirement from these statutes that you have to be able to comply with certain mandatory practices? These are all things that you need to consider before you deal with matters in your business. Managing liability through process. So this is important because as a director, anytime you make a decision, you should be writing it down how you're making this decision, even if it's not just a full written report. At least if you indicated, okay, I've reviewed this report, I've reviewed this, I've done this, and I've done that. And now I've come to the conclusion that this is appropriate. I've also gotten reports from this accountant, and I've looked into a tax corporation to see if they can review it. These are things to consider, because if you're not aware or knowledgeable in that area of that knowledge of that area, then you may become liable if you didn't do your due diligence. As I said, there's a duty of care. You have to do your due diligence. So managing liability means writing everything down and making sure you keep those informations for your purposes. So you're protecting yourself, saying, how did you come to the conclusion of dealing with this issue? How, if it's a big issue, especially signing a contract, okay, if you have email communication between parties, they saying, okay, I have concerns here. What are the concerns? And that if that person levies your concern, are you satisfied with that? Are you satisfied that this expert has knowledge and he is providing you with the proper and accurate knowledge? Or should you be consulting another person as well? Because the amount of debt or the amount of the contract or investment is so hefty, you do not want to risk just signing an agreement without actually properly conducting your review of it. So make sure you deal with those, as well as create committees and advisors if you're able to. Find individuals who are in your, or if they're in your organization, if you're a director and you have advisors and committees, this is great because you can get them to do research for you, provide you with the research in that organization that will help you be able to look at all of these factors. Okay, this is all the negative aspects of this project. This is all the positive. What are the government reviews? There are reports sometimes in government municipalities about specific acts and specific contracts, which you can also look into. These are all things that can be looked at. So also make sure that your board has an education and continues to go into a review of educational requirements for those particular areas and updating themselves on a regular basis. That's important. Consider these aspects when you're dealing with any kind of business transaction that will be impacting your liability. And don't forget the insurance, because you can always get director's insurance, which will help you in case of a lawsuit. The lawyers will be paid for as per depending on the type of insurance you get. So make sure you look into that too. Review the insurance before you sign it. There's also high risk situations for directors. So what are these? These are specialized knowledge areas. So if you are in a field where you're not dealing with any financial, like let's say you have to deal with financial matters because you were hired as a director for the financial purposes. In this stance, you would have to make sure that all the financial documents are appropriate and they are accurate. So you should be reviewing them according to the standards set by the corporation. If there is no standard set by the corporation, then you should be making sure that you need to review them at least once a month to see if there's any concerns, or make sure that if you have committees that they're bringing these things to your attention on a regular basis if errors, issues, concerns come up. Because as a director, you're the last line of defense for the corporation. You're the one who they're going to look to obtain this next step and the direction that the corporation should be heading in that aspect. You will have to look at all of the factors, including if your expertise is not in that area, can you rely on the individuals that are giving you this expertise? And are they giving you a proper report or a proper understanding of what these expertise are? So think and consider all of these positions and make sure that you actually deal with them accordingly. And participation on issue-specific committees. Make sure that you actually attend these committees if you are making committees, so that you are actually understanding what is going on in the business. And if it is a different, even if they're on different areas, it's always better to attend to see what the issues are that's been considered in those areas, and if they actually fall in under your expertise or under your requirement as a director. When you are aware of red flags, make sure that you actually do your due diligence. Make sure that you basically cover yourself from every other aspect by either reviewing it, writing reports, putting down the issues and concerns, and making sure that you're actually reviewing any aspect that might be concerning, and contacting the experts if you don't know. Don't rely on chat GPT or AI, please, because although they are foundational information, make sure that you review with an actual expert who has knowledge and experience, who has been in the field. Use AI as a foundation. That's it. Do not use AI as an expert, because if you do, it can backfire. A lot of individuals, even lawyers once, have taken a factum and prepared a factum based on AI, and they ended up in court with the cases being all false, which meant that this lawyer's case was completely flawed. And the judge looked at the individual going, where are these cases? Now his credibility is shot. As a director, that is something you want to avoid completely, because if your credibility is shot, people will not be able to respect your choices and your decision-making skills. In summary, so make sure to act with honesty, diligence, and loyalty. Balance stakeholder interests wisely, and seek legal advice and document decisions with a lawyer or other experts within that field. Whichever, if you're in technology, make sure you look at the experts in technology. If you're looking at accounting, financial stuff, go to an accountant who specializes in that knowledge. If you're looking at building requirements, go to the expert who does construction. So look for or architect, whichever is probably better for your specific needs. So depending on where you are, what your needs are. So look into it, do your research, do your due diligence, make sure you take that added extra care to make sure that your liability is reduced. And now I would like to thank everyone for attending today's seminar, and I really do appreciate everybody being here today. And We'll see you next week for further seminars. Just wait and stay tuned. We might have special guests eventually in the next couple of weeks, and I look forward to giving you guys more information about how to conduct and run a business as a business lawyer, and founder of my own law firm. Thank you.